I'm Dr. Jeff Kieliszewski, forensic psychologist. Welcome to my YouTube channel. Oftentimes when we talk about forensic psychology, the first thing you think about is crime and criminal cases. But if you've watched my other videos on forensic psychology, you know that the definition of forensic psychology is when psychological science is applied to legal situations. So forensic psychologists also do work in other courts and in other legal situations. So forensic psychologists often do work in family court cases, probate court cases, disability cases, workman's compensation, civil litigation, anytime psychological science is applied to legal situations. Now, one area where forensic psychologists frequently work is in family law. And family courts typically deal with divorce and custody over children issues. Now, family courts do a lot of other things, but that's really the bulk of their work. Now, working as a forensic psychologist in family court cases offers a lot of challenges, some unique challenges, and it's an area where you better know what you're doing because your work could have a profound impact on people's lives. Now, today I'm going to talk about some of the specific challenges of working as a forensic psychologist in family law cases and talk about some of my experiences in this area. So frequently, a forensic psychologist will be brought into a family court case when there's a need to conduct evaluations for the court. And oftentimes there are a couple different types of evaluations the forensic psychologist may be asked to perform. The first one, and probably the most common, are what are called psychological capacity or fitness to parent evaluations. This really answers questions for the court about, does this person have any type of mental illness, major psychological problems, problems in their personality, or active substance abuse problems? Are there any areas that would make the examiner or evaluator concerned about this person's ability to parent? Is it impaired by some type of psychological malady, a lack of knowledge? Is there data that would suggest that this person may have a difficulty in operating within a functional co-parenting relationship? The second evaluation that forensic psychologists are often called on in family court cases is what's called a child custody evaluation. This is more in depth. This usually involves doing a capacity or fitness to parent evaluation of both parents. It usually involves interviewing the children or having the children involved or evaluated. It also looks at other evidence that the court has in this case. And in custody evaluations, in many states there'll be what are called custody factors listed in the law. And these are things or factors that the court needs to consider when making decisions about custody of the children or parenting time. And the evaluator will weigh in on those. Sometimes in custody evaluations, the evaluator will be asked to actually set a parenting time schedule. In some states, people who do custody evaluations as forensic psychologists actually have some legal power to impose mandates on the parties or the parents involved. Now, the first challenge in this type of work is that laws pertaining to child custody, divorce, parenting time, often do not adequately define the process or procedure that would be involved when there's a forensic psychologist involved. Oftentimes it will not define what a capacity to parent or custody evaluation is. Now, this can vary widely from state to state. So for example, in California, the law is very specific about who can do this type of work, what this work entails, what type of training the person needs, what the evaluation should look like. And in California, there's a certification process you go through as a forensic psychologist so that you're considered competent and able to conduct these types of evaluations. And in California, you also, with that certification, get some degree of legal power over mandates that you can have the court order for people involved in these situations. Now, I work in Michigan, and the law in Michigan around parenting and custody and forensic psychologists and evaluations is pretty vague and limited. It doesn't really define what a forensic psychologist would do, how they go about doing the evaluations. It's sort of wide open. So that can be a problem. Now, if you've watched my other videos on forensic psychology, one thing that I hope you picked up on is that forensic psychologists really like having specific laws and language and statutes that define what we do or what we're supposed to do, what questions we're supposed to answer, or even what the structure of a report should look like for the court to use in order to assist them in establishing what's called the trier of fact, basically making their decision based on evidence. Now, as a forensic psychologist, sometimes you might be pulled into situations where there is not a specific law or there's not specific language in the statute that defines your role or defines what you do. So then what you need to do is you need to go to the research literature and the professional writings about these situations in order to define what your role is and what you should do. Now, there are some guidelines. So the American Psychological Association, the Association of Conciliation Courts, the American Academy of Matrimonial Lawyers put out guidelines on how to do these specific evaluations, typically capacity to or fitness to parent or custody evaluations. But these guidelines are guidelines. They're not rules, and they're kind of vague. And when you do this type of work, you actually need to know other areas of research that are important in order to answer questions for the court. So for example, you need to know about child development research. You need to know about bonding and attachment. You need to know the scientific research on children's adjustment to divorce, at what age and what type of parenting schedules work for different kids. You need to know the research on divorcing parents' mental health. You need to know the research on trauma, because if a family's divorcing, it's not uncommon there was some type of trauma that occurred, right? Parents fighting, other types of things that may affect everyone that's involved. Now, so with the lack of specific language and statutes or legal established guidelines in order to conduct these types of evaluations, in some states, in fact, I would say in most states, you will have clinicians that will get involved in doing this type of work that do not have the training or the background or the experience or really the competence to do these things, but they insert themselves in these cases. Also, you will have sometimes judges or family court referees, particularly if they're new to the bench, that are not very educated on the research behind these topics. For example, child development. And should a 9-year-old have a different parenting time schedule than a 15-year-old, okay? And also, they might not be able to spot when there's a clinician doing this type of work that obviously doesn't have the level of understanding that's required, or be able to really find what clinicians may be unscrupulous or unethical. Also, what happens sometimes without specific language in the statute and without laws around these types of issues that define everything, is that sometimes referees and judges, and I run into this all the time, particularly newer referees and judges, they might write court orders, usually manipulated by attorneys, to conduct work or to ask me to provide an opinion that I can't ethically or scientifically support. All right, now one of the biggest problems in these cases is that you get clinicians that sometimes ethically compromise themselves to be involved. So I do a lot of consulting in these cases, family law cases. I've had to provide clinical supervision for clinicians who had sanctions against their license because they acted unethical in one of these or in these types of situations. So for example, you might have mom's therapist writes a letter to the court that said dad has narcissistic personality disorder and he shouldn't see his kids. Well, this therapist never even saw dad and is providing a letter to the court about an opinion of diagnosis of someone they never saw. I've seen that happen dozens of times. You might see a person who starts out, a clinician that starts out as dad's therapist, as dad's going through a divorce, and then they somehow get themselves appointed as the custody evaluator. Well, basic forensic psychology ethics 101 says you should not have dual roles in legal cases. You're either the evaluator, the examiner, or the therapist. You can't have dual roles. Sometimes you'll see an evaluator or a clinician that's in cahoots with the lawyer, and you'll see what's called ex parte communication, where the lawyer's calling them, emailing them, really trying to massage them and manipulate them to have findings that would align with the agenda of their client. A second problem that we see in these cases is the rise of this cottage industry around divorce and child custody cases. These cases can be very expensive, and frankly, they can be lucrative as a clinician when you do this kind of work. So, unfortunately, with a lot of money, angry clients, and adversarial situations, there will be clinicians or entire clinics that take advantage of these factors and insert themselves into this market. You will see clinics or clinicians that this is all they do, or this is most of what they do. So a lot of times in those situations, rather than the evaluator being an objective evaluator, they may try to keep attorneys happy so that they're sent more work. Some of these clinics, there'll be a custody evaluation performed, and the evaluator recommends that each parent go to individual psychotherapy in that clinic, each child go to counseling in that clinic. There's a family counseling intervention. There's a co-parenting counseling. Recently, I had a few cases where there was a clinic that every custody evaluation, the children were recommended to go to equine therapy to help them cope with the divorce. Equine therapy is a therapeutic intervention where you use a horse. There's no research that supports that equine therapy is established as a treatment to help children cope with divorce. So what ends up happening in those situations is that someone will go to a clinic for an evaluation, and it turns into the family spending literally tens of thousands of dollars at this clinic. Also, cottage industry stuff. There are lawyers and clinicians who specialize in what they call parent alienation syndrome. By the way, there is no such thing as a scientifically supported or empirically validated clinical diagnosis of parent alienation syndrome. Now, do parents engage in alienating behaviors where one parent maligns the other and tries to get the kid on their side? Yeah, that does happen, and it is damaging. But there's no clinical condition that emerges from that where the only way to treat it is to prohibit the child from having contact with one parent and sending the child several states away to a therapeutic camp that specializes in this. Now, I'm not exaggerating this example. I've seen it. There is an entire cottage industry on this parent alienation syndrome that's very well established, has big impacts on some of these cases, and it's very expensive. Some of these attorneys will travel throughout the state, throughout different states, particularly if there's a lot of money involved, bring in their own experts from all over, and a lot of money again ends up being spent, and a lot of misinformation and information that's presented as scientific, but it's not scientifically validated. And this has a big impact on people's lives. And again, it's an industry. The third, and the biggest challenge in family court cases, for me and in my opinion, are attorneys. Attorneys. So we have, by definition here, an adversarial situation, a legal fight. Now, there are some attorneys who work in this area that are good people, that they want the pain and the fight of this situation to be minimal. They want to do a good job for their client, but they also want to lessen the pain for everyone that's involved as this family is breaking apart and changing. But there are plenty of attorneys out there who are scorched the earth types in this type of situation. Some have told me I'm just following client orders. Some don't manage their clients very well, and they end up hurting everyone in the process and costing literally tens of thousands, sometimes $100,000. There are many attorneys I've seen in this area that are more than happy to run up their client's bill and the other side's bill. Sometimes have them sign away property to the attorney to help cover their bill. And sometimes these attorneys will really stoke the fires of conflict for their own financial benefit. Now, doing this work for 20 years, I dealt with all kinds of attorney behaviors. Most of these have been aimed towards trying to manipulate me as a clinician. This can be the form of trying to be my buddy, take me out to lunch, free tickets to sporting events, offer me free use of their condo in Florida. Other ways may be asking me to weigh in on things or conduct evaluations in a manner that are not consistent with ethical standards. They may have things written into court orders that I can't ethically do, and then I have to go back and get both attorneys involved and have them change the order. They may try to call me on the phone to chat about the case, and earlier in my career they would do that, and then they'd misquote me in their filings, so I don't take any phone calls from these attorneys anymore. Anything they want to ask me or say to me, they put in an email, and when I respond back, the other attorneys CC'd on it. Some of these attorneys try to manipulate me are attorneys I've had good relationships with. Some, when they began in their career, I would do consulting with their law firm to help them. And then they try to pull stuff on me all the time. There'll be other attorneys that outright try to bully me. I can't tell you how many times they've sent me a ridiculous subpoena, and I refuse to comply with it. If an attorney sends me a subpoena, it really doesn't have the legal weight. They can't put me in jail. If a judge sends me a subpoena, I better comply, or the judge could put me in jail. And these attorneys will, particularly the ones who don't know me or haven't worked with me, and threaten to have me thrown in jail if I don't do what they say in the subpoena. And I say, go ahead, throw me in jail. I didn't know that your law degree gave you the power that you could issue a warrant for my arrest. And then they say, well, I'll do a show cause and bring you in front of the judge. Go for it. And I'll tell the judge how ridiculous your subpoena is and how it's unethical. They don't. Sometimes they'll refuse to pay me. And then they're on my naughty list and they got to pay a retainer up front. And if they still don't pay me, then I file a claim in small claims court. And it's very embarrassing for an attorney to go in front of a judge who used to be an attorney that they probably know and say they're not going to pay their experts. Sometimes where I've had these attorneys that try to bully me on the stand, sometimes it's kind of shown off to their client. Obviously, doing this so many years, I can combat that stuff easily. So some attorneys will use you, tell you you're the greatest thing ever, and then when they try to manipulate you and you don't do what they want, they don't use you anymore. Fine by me. So dealing with these attorneys can be so challenging and frankly annoying and aggravating that I have been considering just not doing this work anymore, to be honest with you. It's sort of not worth it to me at times. But what's happened is that I've been around long enough, and in the area where I work, there are two main counties, which probably the population encompasses 1 million people. So it sounds like a lot of people, but it is a bit of a small town, and when you've been around long, courts know who you are. So what's happened now is that I get a lot of my work referred directly from judges. The judges know my work. They know I'm not in cahoots with any attorney. They know I'm going to follow the ethical guidelines. So I haven't cut that work out yet, but I'm still considering it. Anyway, this is a topic that I could probably talk about for hours. I gave you kind of an overview of my perspective of what the challenges are, and specifically the challenges that I see and that I've dealt with in not only conducting these evaluations, but consulting on these cases, and also, like I said, being involved in supervision with clinicians who've not followed ethical guidelines and had some sanctions on their license. Now, if you have any experience in this, please comment and share with us. If you have an interest in forensic psychology, subscribe to me here. There's plenty of videos on all different areas of forensic psychology here on the YouTube channel. You can also follow me on social media. I'm on TikTok, Instagram, Facebook, Twitter, X. Everything is under Dr. Jeff Kieliszewski, forensic psychologist. Thanks.